Welcome to Court Beyond. In this episode, we delve into two courtroom cases where past actions and repeated offenses collide with the law. Our first case involves Crystal Vogan, a defendant facing a state jail felony for theft of property. Previously on deferred probation, she now confronts a 2-year state jail sentence, suspended and probated for 5 years, along with a $10,000 restitution order. The courtroom examines her criminal history and evaluates whether she can comply with strict probation conditions, including supervision and restitution payments, while avoiding the full consequences of her felony conviction. The second case focuses on Kylan Douglas, charged with obstruction and retaliation, a third-degree felony. The judge considers his prior offenses, juvenile contacts, and probation violations, weighing how these factors affect his 3-year deferred probation with a $500 fine. Every action, from court behavior to past probation breaches, is under scrutiny, making the hearing a decisive moment for Douglas. Both cases highlight the tension between repeated offenses, legal accountability, and the possibility of redemption. How will these defendants navigate the court's examination? Can they satisfy probation conditions and avoid harsher penalties? Now we begin with the courtroom proceedings of Crystal Vogan. Let's dive into the video.
All right, man, you're Crystal Vogan. And Ms. Vogan, you were here yesterday for sentencing in cause number 25 DCCR 0026. Just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is...
Yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, the court, for her actions yesterday. They explained to her as far as what we were as the case, the rejection was there on the deferred. You did kind of at that point, it would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understood how it may affect her with her job, but she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited, we're going to leave it to the court, but we would not be inclined. We're on probation after where she acted and due to her criminal history. So we would, if the court wants to allow her to be straight, that's fine. I understand.
Yeah, well, that's what your argument was yesterday.
Yeah, well,
to continue, for me to go forward. So, I mean,
true.
The most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation. And then I could kind of reinstate everything up to the plea and all of that. So we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's fine.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change. And that's what everyone's agreement is. Is that correct? And I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. All right. Then what I'm going to do, let's see, restitution. And the restitution will be that $10,000. And that's everyone's agreement as well, correct?
Yes, correct.
All right, then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution and to follow all of the rules and conditions of probation. If you do this, this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI, but y'all can do that away. You have them? Okay.
Judge, it is up your performance, but I'm able to tell you.
Yes, ma'am.
Hey, I was not the last, but I was here and my actions.
I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation, as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said. You have to be cordial. Thank you for your apology. You can go back with the bailiff.
Now, we turn to Tylen Douglas, facing a third-degree felony for obstruction and retaliation. With a history of juvenile contacts and previous offenses, every detail of his behavior and past probation violations is under the court's scrutiny. The judge must decide whether he will navigate probation successfully or face the full consequences of his actions. Let's dive into the video.
Good morning. Are you Tylen Douglas?
Yes.
And will your client waive the formal reading of the indictment?
Here we are.
Mr. Douglas, in cause number 25 DCCR 0895, you're charged with a third-degree felony offense of obstruction or retaliation from June 5th of 2025. And how do you plead to that charge?
Yes.
I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Those papers on the tablet that you signed, did y'all go over them?
Yes.
And do you understand those papers that you signed?
This is for probation, right?
Yep, it looks like so. Do you understand if I follow the agreement that you made with the district attorney that you'll?
Read it to me.
I will in just a second. So listen to my question. If I follow the agreement that you made, do you understand that you've waived your right to appeal, which means if I go along with the agreement, you can't change your mind later. Do you understand that?
Yes.
And it looks like the agreement that you reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand that?
Yes.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, sir.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
There you are.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back.
PSI?
Hang on. A pre-sentence report is a PSI, so I'm going to get a PSI done. and that'll give me more information. We'll come back later for sentencing.
Judge,
Hang on. Ms.
our notes
Malfina.
indicate that he has quite an extensive laundry list of juvenile contacts with the law.
Okay.
I would like to reserve the right to ask for at least ISF cognitive to get him on the right track if the court thinks that's appropriate.
Yeah, you were born in.
That would
How
be
old
my
are
only
you?
objection.
Yeah.
Yes, I
Okay.
will.
So I'm not going to adjust the bond based on the age and the nature of the offense and the fact that there's some history I want to look at before we go through with sentencing. All right. So you can go back with the bailiff. Probation will come see you.
What we've just witnessed in these cases are the high stakes of breaking the law, from habitual offenders facing decades in prison to defendants navigating probation for serious felonies. Every choice carries weight. These courtrooms reveal the tension between justice, consequences, and the limits of leniency. Stay tuned to Court Beyond for more real courtroom drama, where the truth is revealed and justice never sleeps.